Hello, everybody. I'm Carrie White, the Marie Center Project Coordinator, and I welcome you to our webinar today entitled Secrets to Share with Deaf People About Interpreting in Court, presented by Carla Mathers. I have some housekeeping items I need to go over with you before we get started, and at the end I will repeat some of the information for those who came in late and also to clarify if you didn't catch the first time. Captioning and interpreters are provided. The streaming window opens automatically. There is a tab for the audio and video on the far right. Click on the bottom corner and a menu will drop down. Click Detach Panel, then you can resize the video box. To open the captioning, click on the captioning icon on the toolbar. Windows can be closed or sized to create your personal viewing environment. The chat window can be made bigger by pulling it out. You do this by clicking on the icon box in the upper right corner of the chat box to access the menu and make the chat font bigger. If you have technical issues, use the chat function and a member of the Clearinghouse staff will aid you. Questions for the presenter will be used in the chat function. Please write down your questions at home and then wait for Carla to ask her questions, then type them into the chat box. I also want to mention CEUs at this time. If you are logged in and watching individually, at the end of the webinar, when you X out, a survey will populate. The survey will ask you questions about your experience with the webinar and also ask you for your CEU information at that time. That is for individual users. If you are in a group watching this and you have many people, you can have the leader of the group fill out the survey, but the rest of you need to fill out the sign-in sheet that was sent with the webinar link. If you fill out the survey online in your name, you do not need to put your name on the sign-in sheet because I will already have your information. The sign-in sheet is for groups of people only because I will not have information from those who are unable to fill out the survey. Okay, without further ado, I would like to hand this over to Carla Mathers. Thank you.
Thank you, Carrie. And welcome back, everyone. We have 98 people on this webinar right now, which is amazing. We have deaf folks. We have people from Hawaii, as far away as Alaska. So it's really nice to see such a diverse group, and through this mechanism we can hit so many people. And not to mention that we thank the Marie Center for it being free. In case you weren't with us for the first time, this is the second in a series we're doing this summer. And I have a disclaimer to state about my use of language for this presentation, in case you missed it the first time. It's fairly standard practice in the ASL court interpreting industry to sign our presentations in a language we all have access to. Because of the technology that we're using for this particular webinar, we're not able to do that. So the best workaround that we've found, because of the limitations of the technology, is to provide interpretation and captioning. So I apologize to my deaf colleagues and know that we are working on a fix for the next series. My other disclaimer is that nothing that I say during any of these series should be constituted as legal advice. Clearly, I'm only licensed in Maryland and the District of Columbia. This topic, secrets to share with deaf people about court interpreters, is something that Anna Witter-Merrithew and I talked about a lot before kind of figuring out how to do a presentation. We wanted some content that was valuable to the deaf community, our consumers, and something that would help them understand a little bit better our role as legal interpreters. So The content may not be new to some of you on the list who have a great deal of experience in training, but we're hopefully packaging it in a way that it'll be easily shared with the consumers you work with so that they can understand better what we do. In my classes, I often tell people that we have an obligation to correct misunderstandings about what court interpreters do and should do. And even in my own interpreter training program, way back in the day, they kind of drilled it into us that confidentiality was paramount, that nothing we would do, that we would disclose no assignment-related information at all across the board. And we told deaf people that. But those premises conflict with the rule of law. And there are many, many times that we are obligated to share assignment-related information, for example, among other things. And we haven't told deaf people that yet. So that's one of the things that this seminar hopes to achieve, is to be able to put those differences and those expectations of court and legal interpreters highlighted in a way so that we'll be able to explain to them when we work with them. Sorry, I was just reading one of the comments. I guess I should put the PowerPoint up. Sorry. So, again, secrets court interpreters should share with deaf litigants. Good. The next slide is just going to be an overview to show you the different topics that we're going to go through. And at the end of each topic, I'm going to pause and take questions. So take a moment to read the slide. So we have different rules that apply when you're outside of court versus inside of court, whether it's outside of court legal work or regular community interpreting, different rules apply. The RID, Code of Professional Conduct, always applies, but in certain legal settings, it has to take a back seat to the rule of law or other legal principles, such as privileged communication, that affect the work that we do as a legal interpreting. So the expectations from our consumers may not recognize and probably have never been told that these differences exist. So some of the differences relate to the evidentiary doctrines and primarily confidentiality. An evidentiary doctrine is a rule that says what evidence can be admitted and what evidence can't be admitted. And there are evidentiary doctrines that relate to interpreters. With respect primarily to privileged communications, being subpoenaed to testify, which is the ultimate breach of confidentiality, and testifying in court to set the foundation for an officer's testimony of, for example, a confession by a deaf person. We'll talk about ethics, rules, and protocol for the court interpreter, both the proceedings interpreter and the table interpreter, and some of the ethical issues and protocol issues that are different, such as conflicts of interest, conflicts that make the interpreter appear to have a bias, and prohibitions on giving legal advice, and how those things may or may not comport with the expectation of what community interpreters do. Finally, we'll talk about the different modes of interpreting and when they're used. Of preparation, all of these things that we're talking about that are different for court interpreters than community interpreters needs to be explained to deaf people. So we'll have a summary on how to do that. And finally, we'll talk some about working with certified deaf interpreters. Again, we'll have an opportunity for questions after each topic and at the end if there's time. And that is the roadmap that we're going to follow this fine afternoon, unless you're on the West Coast, and then it's the morning. Take a moment to read the slide. The code says that interpreters will keep all assignment-related information confidential. But this is not actually true. And that's because of the law of privileged communications. The only time that an interpreter actually cannot be forced or subpoenaed to share information about what happened in an interpreted interaction is if the assignment is privileged, and if the deaf person does not waive that privilege. So anytime an interpreter is working in a non-privileged setting, which is most of the time, unless you're a DRS interpreter or sometimes a medical interpreter or mental health interpreter, most of the time the work that you do is not privileged. So anytime an interpreter is working in a non-privileged setting, they can be forced to disclose the communication, even if the deaf person doesn't want that communication disclosed. So that's the key principle that needs to be shared with the deaf community, instead of us telling them that we're going to keep all assignment-related information confidential. There are important evidentiary purposes behind why an interpreter needs to testify, to lay that foundation for the officer then to later come in and testify. So just briefly, because now you know that this rule exists, but it's also important to understand a little bit behind what a privileged communication is and when it applies. We have privileges because a layperson is going to a professional to seek advice. And we need to ensure the layperson that if they reveal something that's embarrassing or illegal, for example, if they admit to a crime, that they can feel confident that their communications won't be repeated. So it encourages truthful and fully forthcoming dialogue between a professional and a layperson. So privileges are governed by state law, and there are a few that are universal, like the attorney-client privilege, but the rest of them really depend upon your state statute. Mostly, we have heard about doctor-patient privileges, priest-penitent privileges, the marital communications privilege, but the question is whether there's an interpreter-consumer privilege, and there isn't, except in a few places, like Texas, where they passed a statute criminalizing an interpreter for a breach of confidentiality. However, that's not actually a privilege. Excuse me. So for the most part, there is no interpreter-consumer privilege. The elements of a privilege are that the communication must be made in confidence or with some indicia of the intent that the communication be confidential. If a third person is present, the privilege is destroyed unless that person is necessary for communication. So that's obviously interpreters. The presence of an interpreter does not destroy a privileged communication. The second, there has to be a communication, and the communication has to be between the client and the attorney and for the purpose of legal representation. If those factors are met, then both the attorney and the interpreter cannot be forced to divulge what was said unless the deaf person, the client who owns the privilege, waives it. So if those set of circumstances do not exist, then you're not interpreting in a privileged setting, and you can be subpoenaed to testify and breach communication. So what that means is a couple of things. One is that every setting that you go into, whether it's legal or community, you need to be fully cognizant that everything you say or do may be scrutinized later. And the decisions you make may be challenged, and you can be called to testify as to the basis for your decisions. And so that's a caution that we should do anyway. It's not just your interpretation may be challenged, but it's your conduct. And it also means that we need to tell deaf people this. We need to tell them that you can be forced to testify. You can be forced to disclose information should you be subpoenaed. So now I want to talk about what it looks like when an interpreter has to breach confidentiality by being subpoenaed. The law of evidence permits only people who have personal knowledge of an event to testify to it. Information that's not personally observed but repeated in court is called hearsay. And the law considers hearsay to be unreliable. We can't trust it, because the person who personally observed the event is not present to test their recollection of that event, to test their memory, to test their ability to perceive the event that they're saying that they perceived. They're not present. Simply the person who they told or repeated their version of the events to is present. So we only have someone with secondhand knowledge. And in court with witnesses, we want the person who has firsthand knowledge. So interpreted interactions by definition are repeated interactions. By definition, they're hearsay. So if you look at the slide, you see the deaf suspect confesses. He does that in sign. And then the interpreter repeats it in English to the officer. So that's the first repeated statement that has to satisfy some hearsay rule in order to be admitted into evidence by the person who has personal knowledge of the confession. So the interpreter repeats that confession to the officer, and then later the officer goes into court and repeats the interpreter's repetition of the deaf person's confession in court. So that's the second instance of hearsay. It also has to meet some kind of evidentiary rule in order for the officer to testify to the confession. So interpreted statements are inherently double hearsay, which is defined, hearsay is defined as an out-of-court statement, which is repeated in court, and we want the jury to believe the content of the statement. And that would be hearsay unless an exception applies. So, if no exception applies, first we have the first statement, which is a confession, and has a long-standing exception that confessions are highly reliable, so we permit a person who hears a confession to repeat it in court. So the first statement could be repeated by the interpreter in court. But if we want the officer to testify to the confession, we have to figure out how that second statement qualifies as not hearsay or fits some exception. And the way the courts have done that is to apply what's called a joint agency test. The reason we're talking about this now with secrets to share, excuse me, is because the joint agency test to permit the officer to testify to the confession requires that the interpreter take the stand and testify, not about the confession, but about a series of factors that help us build a foundation for the officer's testimony. The factors have to show that we can trust that the interpretation wasn't inaccurate and that the interpreter didn't have any reason to skew the interpretation. Again, the interpreter has to take the stand and testify, and that is information that we simply haven't told the deaf community. Those factors are this. So authentication is just another word for foundation. You've heard foundation either on TV or in court before. You've heard the objection, it lacks a foundation. Well, the actual word is authentication, and it simply means that some evidence has to be introduced so that we believe that the interpretation was more likely than not accurate and without influence from any improper relationships. Nazemian is the name of a federal case that many states and most other federal circuits have adopted the factors set forth in that particular case. And the inquiry really goes to whether the interpreter had, at the time of the interpretation, the skills to do the job, and whether there was no undue influence that would have biased their interpretation. So the interpreter testifies who they are, what are their credentials, what is their training, how did they get to the assignment, who retained them. Impartiality in the legal setting means, do they know any of the parties? Is there a reason that they might skew the interpretation either in favor of one side or the other, or against one side or the other? Again, a general question as to their qualification and their certification. We think that an interpretation is more likely to be accurate if there was something in the setting, like the police station, that impressed upon the interpreter the importance of accurately interpreting. That could have been an oath, or what we call an oath substitute. So normally there isn't an oath in the police station, but there may be a document that the interpreter has to sign that says that they interpreted to the best of their ability. That would make it more likely that the interpreter was an agent of the parties and that the interpretation was authentic. And finally, and probably most importantly, the interpreter has to be subject to cross-examination so that one side or the other can test their reasons or their motivation to skew or their relationships or their skills. They have to be subject to cross-examination. So while we often think, I'm getting subpoenaed, they want me to tell them about the confession, you could see from this foundation, they're not really asking about what did the deaf person say. They're really asking about who are you and what qualified you to do the interpretation, say, at the law enforcement environment. So it is sharing assignment-related information, and it does fall under that rubric of things that we've told deaf people all along that we won't do. And when I go through this, the one thing that I always like to read is just to show you that I didn't actually make this up. It's a case from 1892. And I'm just going to read one part. And for the lawyers who are on the list, and I know who you are, it's Commonwealth versus Bose, V as in Victor, OSE, 157 Mass 393. Okay, so this was in 1892, right? And they were talking about having an interpreter called to the stand to testify that there was no bias or impartiality. So they said, when two people speak different languages and cannot understand each other and converse through an interpreter, they adopt a mode of communication in which they assume the interpreter is trustworthy. Each acts upon the theory that the interpretation is correct. Each agrees, impliedly, that his language may be received through the other. And this is the part that says you have to testify. If nothing appears to show that their respective relations to the interpreter differ, they may be said to constitute him their joint agent. So, if nothing appears to show their relations to the interpreter differ, what that means is we have to know what their relationship with the interpreter is. So they aren't going to testify to that. We call the interpreter to the stand. We ask them how they arrived at the case, not did they drive or did they hitchhike, but who retained them and whether or not they know the parties, so that we can see that nothing appears to show their respective relations to the interpreter differ. Right. So the point. When we tell deaf people that all assignment-related information will be confidential, it just isn't true. In fact, we should be yelling and screaming the opposite. We should be telling them, if we know we're in a non-privileged setting, don't tell me anything you don't want repeated, because I can be subpoenaed to testify. So I'm going to move on to court interpreter roles after I take a moment and look to see whether or not you have any questions. I have a question obviously from an attorney. Congratulations, Catherine. She says, when talking about waiving attorney-client privilege, you said that the deaf client would have to waive it. Can you address situations in which privilege can be inadvertently waived, such as if someone in a hallway happens to overhear a conversation? Right. There are lots of ways to inadvertently waive privilege. If the third person is present, such as in that hallway, and they overhear the conversation, then that can breach privilege. In my experience, I've seen sometimes expert witnesses will break privilege not realizing that they're, or trying to share information with outsiders without letting the attorney know. I've seen that happen. Even we used to just panic when you'd accidentally send a privileged document to the wrong attorney via email or via fax. So there are lots of ways to inadvertently waive privilege. The legal question is, how broad is that waiver? But that concerns interpreters less than it concerns attorneys. Okay, let's see. What did she say about Texas is a question. Texas has a statute on their books that criminalizes the breach of confidentiality of a relay operator or an interpreter. It makes it a misdemeanor, I believe. Brenda asked a really good point. With the deaf community being so small and working in the community for over 15 years, you know everybody. How do you explain that in court, that you've previously worked with a deaf person in other environments? Right. One of the things that I tell judges when I do judge training is exactly that. The deaf community is very small. We're not like Spanish interpreters. You can fully expect that interpreters will have prior contacts, whether professional, meaning you interpreted for someone, or personal, meaning you know them, that they should expect that their sign language interpreters will have prior contacts and they should voir dire them. In the event that they don't, it's simple to make a disclosure prior to taking the oath by saying something to the effect of, after they give you the oath, you can say, my name is Carla Mathers, and for the record, I have a prior professional contact with the defendant in this matter that I do not believe will affect my ability to interpret neutrally and impartially in this matter. And then let the judge decide what to do. But you've made your record, which is one of the things I'm going to define later. You got it down in this in the transcript that you've made this disclosure. And there's a certain kinds of conflicts, obviously, that if you know the deaf person so well, that you don't take those jobs. But for the most part, we are definitely going to know the people we work with, and we just have an obligation to disclose that. Janice Hagen-Toiber, if the questioning of the deaf person in a police station is video recorded, does that preclude the interpreter from testifying? No, because the video recording doesn't answer the questions on the screen. And the questions on the screen are the reason why you're being called to testify. The video is most helpful for the expert witness who's going to review the interpreter's behavior and the interpretation. and give an opinion on that as a motion to suppress. Great. Okay, good questions. So, briefly on to some of the role differences. Most often, when we're hired to work in court, we take the role of what we call a proceedings interpreter. That interpreter is aligned with the court and is called an officer of the court. The duty of loyalty that that interpreter has is to protect the integrity of the interpreted proceeding. They take an oath to accurately interpret, and they interpret for all the proceedings and all the witnesses. So the court interpreter, of course, the RID code applies, but it's in the background because there is a separate court interpreter code of conduct in nearly every state. The RID code still applies to things like law enforcement, with, of course, the overlay of being called to testify. And it applies to table interpreting, which I'll explain. So it is in the background, but it's secondary to the court interpreter's code of conduct and to the rules of procedure which govern our conduct in court. So the ethics are different. Conflicts are, I think, different than what many interpreters think a conflict is. A conflict is defined as a condition that exists which might affect the interpreter's ability to interpret accurately without favoring or harming one side or the other. So it's a condition that exists that might affect the interpreter's ability to interpret accurately without favoring or harming one side or the other. So obviously conflicts exist when an interpreter has a financial interest in the outcome of the case. That's the most obvious and doesn't take a lot of analysis. But less obvious conflicts also exist when there's a relationship with one side or the other. And that relationship, a neutral outsider might think, would color the interpreter's interpretation in one way or the other. So in court interpreting, we have two kinds of conflicts that also don't comport with the deaf community's sometimes their expectations of how interpreters should behave. So we have what we call appearance conflicts, which I'm going to discuss more in the next slide. But essentially, how we behave in court might not comport with the expectations of deaf people. We have what we call decline conflicts, and I was just referring to in the question that someone asked. Under certain circumstances, the interpreter who's asked to interpret has to decline the assignment altogether because the relationship is too pronounced that that a neutral outsider would believe that they could not interpret impartially. So there's a couple of things. One is that in community interpreting, there's also a preference for continuity in interpreting services. You want the same interpreter at a college class throughout the semester. And in court, there are times when the rules of evidence or the rules of procedure require a different interpreter from the person who did the law enforcement to then do the proceedings. So this expectation of continuity that we see in community interpreting is sometimes we're not able to adhere to it in court and legal interpreting, and we haven't told deaf people that. In addition, in community interpreting, there's a preference to have the deaf person choose the interpreter that they want to interpret for them. There's this consumer preference concept that is prevalent in the field. And in court and legal interpreting, that preference is seen as an impermissible conflict. It's seen as the deaf person wanting to pick the interpreter who will interpret most favorably for them. It's even happened to me when I would call the court to get an interpreter for a client, and I would say, I want you to call so-and-so and so-and-so and so-and-so, because I knew they were trained, they were skilled, and they would do a good job. And courts routinely said, no, we're not going to pick who you want, because you obviously want someone who's going to interpret better for you than they would for the other side. Voir dire. I think it's important for interpreters to understand because once you discover a conflict, because discovering conflicts is one of the reasons that an attorney will want to put you on the stand and ask you questions as to your qualifications. So those same authentication questions that we just saw, those are the same types of questions that are asked of the interpreter during voir dire to discover whether there are conflicts of interest. It's one of the major purposes for that. So I know that sometimes interpreters feel that this kind of questioning is offensive to them, asking them about impartiality or their ability to interpret neutrally or accurately kind of ruffles their feathers. But that just makes interpreters look defensive on the stand, and it never really turns out very pleasant. So we have to be prepared to be voir dire, and we need to tell deaf people that there's a chance that it will either make this disclosure before the oath, like I just did, or will be voir dire. Additionally, if the voir dire is going to be substantive, however you say that word, then the court interpreter needs to make arrangements for someone else to be present to interpret their voir dire for the deaf party. So that's something that it's a unique to court and legal interpreting. We don't see that in many other settings that I'm aware of. Another difference is the protocol for interruptions. So that's when interpreters are actively involved in the proceeding because they interrupt the court to get permission to talk directly to the deaf consumer. When we're outside of court, we don't ask anybody's permission to talk directly to the deaf person. We just do it. Or we use our little facial expression to go, what? And then we get a repetition. So in court, all of that negotiation is prohibited. And you need to be really transparent. So we need to tell deaf people that and demonstrate and show them what it looks like when you raise your hand and you ask for permission to ask the deaf person to repeat a name sign or to spell a name sign. And then finally, another huge difference, and I think really runs counter to the expectation of the interpreter as a member of this community, is that we are not permitted to share what we know. We're going to talk about this more because it's disconcerting on a number of levels, how much interpreters really feel the need to share what they know about the legal setting with the deaf people, and there are strict prohibitions against doing that in the Court Interpreter Code of Conduct. So I want to drill down a little bit into some of these differences. There's a perception difference, and we call it appearance conflicts, and how we are perceived in what we do. I think outside of court, interpreters are often appear or are perceived to be aligned with the deaf party, that we're there for the deaf party. You know, whether that's accurate or not, that's the perception that's out there. Some people may even function under this philosophy that part of their duty is to assist in balancing or equalizing these inherent power imbalances that the deaf community has faced as a result of being a minority language and culture in the United States. So that may be the interpreter's philosophy, and that may bear out in the perception of the conduct of how they conduct themselves. So we don't greet deaf people in the traditional manner that we would outside of court, because that's an appearance conflict. We don't walk up and hug them. That makes us look like we're on their side and that we have an undue affiliation for them. We also don't greet each other in the traditional manner that we do in the community. We don't have these side conversations with deaf consumers when we're interpreting. And we don't hang out with deaf consumers before or after an assignment, except in the official discharge of our duty. So this makes us, I think, perceived by the deaf community to be more aloof and more outside and less supportive and less part of the community than a community interpreter would. And so because there are important reasons for maintaining impartiality, it's important for us to talk through these items with deaf people and with the deaf community. So interpreter interaction in court to obtain repetitions and clarifications and assert other needs is different. We're taking an active role in the interaction when we assert a need, but we speak in the third person. We say the interpreter needs a clarification, or the interpreter would ask the court to ask counsel to slow down. We do this because of the record. And we don't sign when we do this because we're an active participant in the setting. And this may lead the deaf person to feel left out. They may feel like the interpreter is violating the RID code because they're not interpreting everything, and they may appeal. They may file a grievance based on that. So there are important reasons why we don't use SimCom or sign and talk at the same time, and we need to talk to deaf people ahead of time about those instances in which we're going to be involved in an interaction that may violate deaf cultural norms, not keeping the person informed and that kind of thing. At that moment, anyway, not keeping them informed, so that folks are aware of it. Another thing is disclosure. When we make that disclosure, which we're required to do when we have prior contact with any of the parties or attorneys or anybody else involved in the case, we are violating confidentiality. So we need to tell deaf people ahead of time. We've met before, I need to tell the court that, and this is what it's going to sound like. So there's a whole deal of uninterpreted information that goes on. Sometimes the interpreter might go to the bench with the attorneys to discuss an interpreting issue outside of the presence of the jury. This is not interpreted, and this is intended to be private. If there's a table interpreter there, that interpreter might be able to catch the deaf person up if the attorney gives permission. But the deaf person may be the witness, and the sidebar may be about their testimony, in which case it's intended to be private from the deaf person because they're a witness. So the interpreter would never go to a bench conference and then back to the witness, the deaf witness, and say, oh, here's what we just talked about. That would be bad. At the same time, this is quite at odds with the RID code. We're to interpret everything, right? And that's what we tell deaf people. We'll interpret everything, when in fact we're not going to interpret things like bench conferences. We're not going to interpret when we take the oath. We're not going to interpret when we're an active participant. So why don't we just SimCom? Because we don't use that technique in court. We know that the research that we have, we know that signing and talking at the same time is ineffective in one language or the other, and usually it's the sign language that suffers. Although I've heard, people speak in glosses while they're signing, and then the English suffers. But the point is, you can't use two languages at the same time. And if you sign and talk, then your syntax is necessarily following English. So the deaf person who uses ASL will not be in the same position as the person who's listening to the English. And if the purpose of signing and talking at the same time is to put everyone in the same position, it fails by definition. Additionally, legal interpreters have gone to some effort to explain the difference between American Sign Language and English. And when the court sees someone signing and talking at the same time, it gives this impression that ASL and English are the same thing. So it sets bad precedent, too, for the interpreters who understand that this isn't an effective technique and don't use it while interacting. So proactively, we let the deaf person know that we're not permitted to sign and talk at the same time, that there will be instances in which language happens that doesn't get interpreted, and give examples. And sometimes sometimes the deaf person will actually know before the uninterpreted information happens. You say to them in preparation, when I raise my hand, I'm promising to interpret accurately. Then they know before you take the oath, as soon as they see your hand go up, what you're doing. Right. So legal advice is knowledge. It's sharing what you know and what you predict may happen based upon legal training and expertise. So interpreters who work in court a lot often gain knowledge of the system, but the knowledge is imperfect. And even when it's perfect, it is unethical to share it, and in many places it's criminal to share it. It is a crime to give legal advice without having a license. And it's not because of the attorney monopoly. It's because you really don't know what you don't know. So that runs counter to the concept within the community that if you have information, you should share it. Right? Deaf culture of sharing information rules. So we have this body of knowledge. We want to help. We want to share it. But in doing so, we're giving legal advice, and it may be inaccurate. Deaf folks may think that you know more because you're hearing and because you're experienced, and so there might be this cultural expectation that you share and help the deaf person out in these settings. You may feel obligated. You may feel like you know enough from your experience, and you may want to help. We all want to help. The problem is, again, is often we think we know, but we really don't know all of the ramifications. So let's take traffic court, for example. If you've worked in traffic court, I'm pretty sure that you know if the officer doesn't show up and the deaf person changes their plea from not guilty to guilty, then the case will be dismissed because the government can't prove their case without their witness, the officer. So we really want to share that with the deaf person because they may come in and go, yeah, I'm guilty, but I have an explanation. Right? So sometimes it's true that the case will be dismissed, and sometimes it's not true. It won't be dismissed in my jurisdictions if there's an accident involved. It won't be, or if there's any personal injury involved. And it won't be dismissed if the person has a long history of traffic accidents or other infractions. And it won't be dismissed if the person is on parole or probation because it's a violation of their probation. So they're not just going to dismiss it. They'll continue it until the officer is present and they can hear the case. So the very last thing that you ever want to have the basis of an appeal be is, but that's what the interpreter told me to do. Right? You don't want the person to go up on appeal and say, yeah, but I did that because that's what the interpreter told me to do. So I think that it's completely appropriate to, if the deaf person asks you, what should I do, you know, to offer to find somebody who can answer that question and offer to interpret that interaction. But you have to be very, very careful about sharing your knowledge in a legal setting. I see a lot of questions, but we're going to get through the next slide, and then I'll be happy to go back and take a look at them, because the next slide is really quick. It's deaf people don't know much about this role, and I think it behooves us to explain it to them so that they can explain it to their attorneys and advocate for themselves, because having a table interpreter present in a serious contested case is a very valuable and important role for litigation counsel, and it comes best when that explanation is coming from their deaf client, so it doesn't look like the interpreter's trying to just get more jobs for more interpreters. So very quickly, counsel table interpreting is a role that is one type of legal interpreting. That interpreter interprets all of the privileged communications. It's a very different role than the proceedings interpreters, but it's not an adversarial role with the proceedings interpreters. This person is hired by counsel. They interpret all of the preparation up to, during, and after the case. They interpret the preparation with any deaf witnesses and with a deaf party if there is one. During the trial, the interpreter sits at the table with counsel, not only to interpret privileged communications, but to watch the proceedings interpreters to ensure that they're accurately interpreting. When there is a substantive error, the interpreter at the table informs counsel, who is able to make an immediate objection. If counsel doesn't make an immediate objection, they waive that right forever. They waive that right forever. So if there is no table interpreter there, they've waived all of their rights to object to any of the interpretation. And that's huge, and that's one of the key factors that anybody explaining the need for a table interpreter can use to convince an attorney to hire one, because attorneys are naturally paranoid about waiving rights. So if you tell them you're waiving your right to object to the errors that will occur, it's very likely, particularly if that's coming from the client, that the attorney will be more enthused about hiring a table interpreter. And this interpreter is their expert, part of their team, who can assist them in a variety of ways with their knowledge and skill. At the same time, this person should be highly qualified and be prepared to be voir dired in case they do let the attorney know of a substantive error, and in case they do have to explain to the court on the record the nature of that error. The court's going to want to know naturally, well, who are you? And who are you vis-a-vis who are my court interpreters? So you have to be qualified to take this role. All right, before we go on to modes, I'm going to take a look at those questions, and if people have other questions, feel free to type them now. Sarah Patterson, too, asked a question about uninterpreted information, asking whether or not the reason that information is uninterpreted and the team interpreter doesn't go ahead and interpret that is that because of scarce resources of interpreters. No, and it's actually, I don't have an objection to the other interpreter if they're not also involved in the interaction, interpreting for whatever the interpreter who is involved in the interaction is saying, as long as it's not a bench conference, because those are intended to be private. And in many places, the defendant, because the defendant has a right in a criminal case to be present at a bench conference, in many places they'll be present by headphone if they're hearing. So there are times when, in fact, you're also interpreting for a defendant who is not on the stand but is at the table, and you're at a bench conference. So yeah, that's certainly an option to have your team do that. So Tawanda asks, when working as an interpreter in the courts, when called to take an oath on interpreting accurately, are you saying you are not required to interpret your part as the interpreter being sworn in? Yes. Yes. When you're taking the oath, you're an active participant in the interaction. You would not be interpreting. If you don't have to have your team interpret it, but if your team is available and they want to interpret it, that's fine. So right, you don't, when you're an active part of the interaction, you're not interpreting. Like when you're on the stand as a witness being voir dire, you wouldn't also be interpreting that. And Helene says, what about modeling consecutive interpreting when taking the oath, interrupting for clarification, etc.? Well, so it's interesting. Lots of people want to have the deaf person know immediately everything that's happening, which is when you use this technique of what is said, and then I inform the deaf person. And as long as that's interpreting, I have less of an issue with it until it crosses the line into private conversation with the deaf person. So you let them, you take the oath. You're done taking the oath, then you let them know, hey, I just took the oath. That's sort of consecutive interpreting. And then they ask you, why did you take an oath? Or what did the oath say? Or, you know, they ask you, that leads to conversation. That's the line that can be crossed. Gail, can you talk about an interpreter continuing to explain something after the attorney has stepped away, not giving advice but explaining? What I can say about that is when the attorney steps away, the interpreter steps away. And I'm not entirely sure what circumstances I would stay and explain something after the attorney has left. So if you have more specifics, but if not, that's pretty much what I'd say. Jody, the traffic court example, this is just while on the job. What about sharing knowledge experience when in a non-related social setting? That's fine, I think, and as long as you're not, I mean, I don't think our code says anything about how you have to conduct yourself in a non-interpreting setting. And of course you do learn things on the job, a great many things, and there is a cultural expectation that we share information. But it just needs to be clear that whether you're in court or out of court, you're not giving legal advice. Great. Okay. So moving on. A couple of things about the different modes of interpreting that we use in court that deaf people may not be familiar with, or may have misunderstandings about when and why they're used. Sight translation is a technique where an interpreter translates a written document orally or visually. It's a hybrid of translation and interpretation. So it's an immediate translation where the interpreter might read a document and then sign it in American Sign Language. We use it in court for forms like financial affidavits, domestic violence, protective order applications, any explanation of rights or forms that the deaf person needs to read and sign and understand. And of course, with consent forms and other legal documents that you're doing a sight translation on, it's important that the attorney be present for the translation in case the client has questions. Sight translation works both ways. You may read a domestic violence protective order and sign it to the deaf person. The person may sign their responses and you would fill out the form. My cat is coming to join us again. Consecutive interpreting and note-taking. Consecutive interpreting is a technique where the interpreter waits for the speaker to finish a source language message before rendering it in the target language. In consecutive interpreting, interpreters use note-taking as an aid to memory. And that it's a concept that's becoming more popular in the legal interpreting field, but has yet to take off, I think, and been generally accepted by many legal interpreters. I think people need a lot more experience and training on how to do it before they feel comfortable. And the good thing is that it's easy to get that experience and training so that people can take advantage of note-taking techniques while they're doing consecutive interpreting, which is usually used in non-English speaking witness testimony. Consecutive interpreting is. It's critical to explain ahead of time to the deaf person because folks aren't used to it. This field, for some reason, has always started with simultaneous interpreting and not really got back to accepting that consecutive interpreting is more accurate. And I think it's a matter of practice and training and practical application. I think people think that if an interpreter wants to use consecutive interpreting, they may be lesser skilled because they can't, quote unquote, keep up with the speaker. So interpreters need to understand why it's more accurate. And in fact, interpreters need to use it accurately in order to reassure the deaf person that they will be able to get the whole story out. I know when my cues or my chunks when I'm doing consecutive interpretation are too short, I can see it on the deaf person's face. They get so frustrated that I'm cutting them off. So it's incumbent upon us to develop those memory techniques to allow us to retain a manageable and a reasonable chunk of information so that the deaf person can be reassured that they will be able to get the whole story out. So a couple of other things about the notes. You need to talk to your team about how you're going to be using them, whether you'll both be using them, whether when you're interpreting from ASL to English, maybe your team is the one taking notes. You talk to your team about what you need notes taken on, whether it's finger-spelled words or numbers. You have to have a system in place. And also you want to reassure the deaf person that you'll destroy the notes, so that you'll destroy the notes and not keep them. And you may want to take a moment during preparation to demonstrate how consecutive interpreting and chunking will take place. In regards to simultaneous interpreting, it's a technique where the interpreter speaks at the same time or shortly after a source language speaker, lagging behind a concept or so, used in many legal settings. Pretty much any time the deaf person isn't a direct interactant, that's not a word, a direct participant in the interaction. So initial appearances, jury selection, opening statements, motions, objections, that kind of thing. I think deaf people are pretty much used, there's not a lot you need to explain to them about simultaneous interpreting except to use it as a comparison to consecutive. Summary interpretation is an incomplete rendition of the main points of an idea or interaction. It's not a mode that is used after the case is called in court, but it has a very important role to be used prior to a proceeding where you're waiting for the case, where you're going through the docket, waiting for your case to be called. I say it's critical because recently I've spoken to people at the RID who've received grievances that interpreters aren't accurately and completely interpreting everything because they refuse to interpret the proceedings up until the deaf person's case is called. And, you know, there's truth in the fact that it may be a couple of hours before the deaf person's case is called. And if there's only one interpreter there, which is reasonable for a 5-minute traffic case, the court is not going to and should not be required to hire 2 interpreters. So you have one interpreter, and if they're interpreting everything up until the time the case is called, then the accuracy may suffer for the actual case. At the same time, the deaf person and the court, well, start with the deaf person. The deaf person thinks that it's completely unfair and they feel completely left out, and they're not in the same position as many people who use spoken language interpreters, because people who use spoken language interpreters oftentimes are somewhat bilingual and they have some kind of understanding of what's going on prior to the case. That may not be the case with deaf people. So, and the courts have an obligation to provide a reasonable accommodation. If they're providing a sign language interpreter, and if the interpreter refuses to interpret at all for that, anything up until the case is called, then the court has exposure to liability, even though they did what they are supposed to do by providing an interpreter. The exposure to liability came from the decision that the interpreter made not to interpret up to the time the person's case is called. So, all I can say about that is that in a lawsuit, the court would probably bring the interpreter in as a co-defendant because it was the interpreter's decision not to provide the accommodation that the court paid for. So, summary interpretation is a great resolution to all of that. You don't just leave the deaf person not knowing who the interpreter is and if there's an interpreter there, and you don't just wait until the case is called and stand up and start interpreting. You can provide a summary of the different cases that are going on prior to the deaf person's case being called and explain to the deaf person why it's not a full interpretation. And when that happens, deaf people, in my experience, get it. And they're far less likely to file an RID grievance, which, like I told you, has been happening. And the courts are not put at any risk for liability or exposure as well. So, before we go on to CDIs, I want to take back and look at your questions. People have been active, I see. So let me just back up here. I'm presuming everybody can still hear me because I see that the interpreter is working. Because there were some issues with some people's audio. I have a question from Suzanne Terrio. Hi, Suzanne. The deposition interpreter, or interpreters used during attorney consult, can he or she be used as counsel table interpreter during the proceedings? Two different things. The deposition interpreter, the interpreter who's interpreting the questions and answers of the witness at a deposition, is a proceedings interpreter. And luckily one of our webinars is going to be on depositions. So the deposition interpreter is a proceedings interpreter. That interpreter can in fact become a table interpreter, but cannot then go back to interpreting any of the proceedings. You've got to keep those lines straight. The second part of your question is interpreters used during an attorney consult, which I assume would take place at a law office, and that interpreter is in fact a table interpreter. So yes, that person definitely can and should be the table interpreter during the proceedings. That preference for continuity that we see outside of court that gets sometimes messed up during court, here's a place where it's really continuity and consistency in interpreting is really important. The interpreter who's doing all the background consultation should be the person who's sitting in the courtroom monitoring, because that interpreter has the most information about the case and can actually tell when an error is being made and if that error is important enough to take any kind of steps. So good question. Percy, site translation. Percy says, in regards to site translation, what to do when a deaf person is fluent but would need clarification with some words or phrases being in legalese? Would the interpreter still do a site translation for those brief points of clarification? And then I know there was a second part to this question. Maybe fluent is the wrong way to explain it, but sometimes a deaf person would like to read the document first and then request interpretation of certain blurbs in the document. What would an interpreter do in this situation? It's a good question, Percy. And again, there's a fine line between giving legal advice and doing an interpretation. And if I looked at the document and the person says, I don't understand this phrase, equitable estoppel. If I knew how to interpret that, I would be okay interpreting it. If I didn't know how to interpret that, or if I didn't know how to interpret it, then I would have to suggest that we ask the attorney. So as long as it doesn't cross that line into giving legal advice, I think it's okay. It's almost like, at times a CDI might be there to clarify on an as-needed or ad hoc basis. So I think that would fall into the same kind of circumstances. Okay, Brenda Atkinson asks, do notes and consecutive interpreting become the court's property? Is it shared with attorneys? There's no automatic, the notes become the interpreter or the court's property. Certainly if the court asks for it, then it should be given to them. It doesn't have, the notes are used for consecutive interpreting, which means they are used to help you render an interpretation. If you're using symbols, if you're using your own system of note-taking, the notes might not make sense to anybody else. But in any event, so I don't offer to share them. If I'm a court interpreter, I don't offer to share them with the attorneys. If I'm a table interpreter, I would offer, if they needed them, to show them or share them or leave them with defense counsel or plaintiff's counsel. Okay, Suzanne Terrio, interpreter during police questioning. Judge, prosecutor, defense attorney are all okay with using this interpreter during trial. Is this an acceptable practice? This is not an acceptable practice if you are an ethical interpreter. And it doesn't really matter that everyone else thinks it's okay, because everyone else is not liable for your interpretation. If you take a look at the code of conduct for your court, it's usually in the canon on conflicts of interest, and there's usually a listing of certain circumstances by which, if you interpret, you cannot interpret in the later court proceedings. And law enforcement is always one of them in every code of ethics that I've seen. So, okay. I think we already covered Jen's question on notes. Well, almost. Are they allowed to be taken from the room? Really, I think that the notes are not really of much interest to the courts because they're simply a method to help you interpret. They're like an aid to your short-term memory. If you're talking about notes that a table interpreter might be taking, that could be viewed differently, but in that event, the table interpreter's notes belong to the attorney and are privileged under the work product doctrine. That's part of the attorney's preparation and work during the case, and the interpreter is the attorney's agent. So I don't see them really wanting our notes as court interpreters. But it's useful to keep in mind that you probably want to make sure that your notes are, that you're comfortable giving up your notes if anybody asks for them, that you wouldn't want to put anything in your notes that, you know, might get you in trouble. No personal comments about the judge's appearance. Okay, Denise, I've had a judge tell me not to be interpreting while I'm waiting. It's frustrating. Any ideas on how to address issues briefly? The comment from the judge is you are distracting people. I'd ask to approach the bench and just let them know that I was hired as an Americans with Disabilities Act, a reasonable accommodation. The deaf person has an interest in, I'd use words like accessing justice, because most of their committees on language access deal with access to justice, or called fairness committees. If I didn't want to deal with it right then and there, and there was a court administrator, I would go to the court administrator and explain that they may be facing some kind of risk of exposure to liability because the court wasn't letting, or because the court directed the interpreter not to interpret, and then I use the same kind of their language being access to justice, language access, those kinds of things. I've had bailiffs tell me that I couldn't stand in the middle of the courtroom, and you know, you just need to be nice and polite and respect their culture. And the next time I went down to the same courtroom, he let me move just a little bit farther into the well of the courtroom. Third time, I managed to get directly in front of the deaf person, and now it's not a problem. So part of it's just educating. They don't understand. Nobody else is allowed to talk during court. They don't understand that we're not talking during court. So I think it's an education issue. Okay, Tawanda says the interpreter can decide not to interpret anything until the case is called. Now, without jeopardizing the court's liability and the interpreters being obliged by the Code of Ethics, providing a summary should suffice the hold of interpreting information. Not entirely sure I understand that question, but I think I do. I don't think it's proper for an interpreter to decide not to interpret anything up until the time the case is called. I don't think that's what you're asking me. I think if you explain it to the deaf person ahead of time, why you're providing a summary as opposed to an exact interpretation. I work in Virginia courts interpreting, and they do not put the deaf person up front. They go exactly by the officer, and if I'm in the officer with who's on the last for that docket for the day, I can be there in the afternoon. So I explain that to the deaf person, and they get it. They don't want me being so exhausted that by the time the case is coming around, I can't guarantee accuracy. So, and another thing I do is, if it's a case that's exactly like theirs, I'll interpret it more accurately so that they can see what defendants are doing in cases that are exactly like theirs. And also, 99% of the defendants I work with in Virginia courts are pro se, meaning they don't have an attorney. So this conversation is about when there's no attorney present, right, which is most of the time in traffic court and things like that. Okay. I think I want to do, because it's 2:19 and I know that Carrie has some closing statements that she needs to talk to you about, I want to get through particularly the working with CDI slides. The slide after that, because you can access these in the archives, the slide after that is simply a summary of the things that we want to talk to deaf people about, so you'll have access to that. And then there's one final slide with information about our next steps, and there's been a change in date for one of the seminars. So let me come back, and then if there's time, I'll take the rest of the questions. So working with CDIs. What it means, what it doesn't mean, when it's indicated, when it should be standard. CDIs are trained and they're competent to provide a native interpretation that is more appropriate in certain settings with certain consumers and with certain interpreters, or with characteristics of certain interpreters. That's what it means. It's a person who has a specialized skill who brings something different to the team than what the hearing interpreter has. Lots of people say that comprises a full team. What it does not mean is that the deaf person is dumb, that the deaf person has minimal language skills, or there's something wrong with that person. It also doesn't mean that the hearing interpreter requesting the CDI is inept. And it would be really nice if the CDIs among us could remember that. And if we could work out strategies together to help CDIs explain the reason why they're indicated in a particular manner without plainly disparaging the hearing interpreter, that would be great. And I think that there are resources that have already been published in the field, and there are upcoming events that are going to focus on the work of court CDIs that will hopefully give us a forum to try to begin some of those conversations. Because in my experience, it's usually the highly qualified hearing interpreters who are recognizing the need when they get to an assignment for a CDI and making that recommendation to the court. We need to tell deaf people that. We need to tell them what a CDI means and what it doesn't mean so that people are used to it. There are certain high-risk settings in which CDIs are standard practice. They're indicated, and more they're standard practice. Those are high-risk legal settings such as law enforcement, such as working with children, such as working with deaf individuals who have other cognitive impairments. There are client characteristics, like I just said, deaf folks with cognitive impairments or other mental health issues that also indicate the need for a CDI or juvenile. There's also times when the interpreter who can hear simply doesn't have the linguistic facility necessary, who recognizes that and requests a CDI. That's usually not the case in legal settings, as I said, but that you can see the market for CDIs could be extremely expansive if they were paired with interpreters who had more emerging language skills or skill sets to fill that gap between school and work. Currently, CDIs are standard in law enforcement settings, in juvenile courts, mental health courts, competency hearings, when you're dealing with deaf people who may be foreign-born, recent immigrants, or have other emergent language issues. And I would send you to the Marie Center's website for a free download of a legal paper that analyzes deaf interpreters, when they're used, why they're used, and the paper also has a 50-state analysis of the court interpreter laws that either permit or do not permit deaf interpreters to work in court, so that you can check out what your own state says. So what if the deaf person says, but I don't want a CDI? What do you do then? What is that line? I think we do, to some extent, need to respect the preferences, but at the same time try to find out what is the reason for the reluctance to work with a CDI. They may have never had any experience. It may be that after giving it a shot, so that prior to the time the court starts, you have a demonstration of the process. And they might have a revelation when they see that it can be accurate and it can be a much less taxing to watch a CDI than to watch a hearing interpreter. And it might be that they're just insistent and then that they don't want one, and so the CDI might be a standby interpreter to assist whenever communication issues arise, or if the proceedings interpreter needs assistance, or if the deaf person isn't understanding and asks for them to clarify. So there's a lot of different configurations, but I think what's key is how we describe the need for what a CDI means, what it doesn't mean, when it's indicated, and when it's standard. And I think we present the work of the CDI as an important factor, and we need to share it with the consumers that we work with. All right, we have 5 minutes left. I just want to show you this side. It's just a summary of the things that we have talked about today. The court's different. You really want to talk about RID confidentiality, that you can't, like you can on the outside world, you can't have these private conversations with deaf people, particularly if they're on the stand as witnesses. That the process for obtaining clarifications is different, and that applies to any time you're asserting yourself in the process. That there will be uninterpreted information, and give examples. That you may have to make disclosures, that you can't offer legal advice, that the court doesn't permit us to sign and talk at the same time in court. You explain the benefits of a table interpreter, then the deaf person can advocate for themselves with their counsel to ensure that a table interpreter is hired. Explain the modes of interpreting, such as consecutive, establish a queuing system, explain note-taking, and the uses of summary interpreting, as well as the benefits of a CDI. So I just want to make sure I get to this slide before I turn it over to Carrie. I'll be back Monday night, 6 to 7:30 Eastern Standard Time. We'll be talking about interpreting in family law settings. And I just want to point out there's a change in the series date. The final session is not September 7th. I apologize for that. I had a conflict, but it will be September 21st, which I think is a Saturday at 1:30 looks wrong. We'll figure out the time and we'll make sure that it's correct on the website. It should be, I think it's 1 o'clock like this one was at Eastern Standard Time. I may have it wrong. Again, you can get archived sessions at this website, and if you have questions, and I'll turn it over to Carolyn now. And thank you very much for your time, and I hope you have a good day. Carolyn?
Thank you very much, Carla. Just a few reminders. RID CEUs can be requested by completing the CEU request form, which will appear after the satisfaction survey is completed. The survey will open once you close out of the webinar software. Submit the survey and you will see a screen where you can click on the form to request CEUs. This form must be filled out to receive RID CEUs. If the survey doesn't automatically open for you once you close out, go to the web page for the webinar that was provided in the email sent to you last night with the link to access the webinar tonight. The link to the survey is at the bottom of the page. A group sign-in sheet was attached to the email that was sent to you. If you watched in a group of individuals, please have everyone sign in and then email the form to me. CEUs will be awarded via the sign-in sheet for group activities or the survey for individual. I encourage everyone to please complete the survey whether you are seeking RID CEUs or not. The listserv for the summer webinars are continuing and provide an opportunity to ask Carla questions and to interact with your peers. Please look for an email that will be sent out on Monday. I also would like to thank Carla and the interpreters, Kirk and Terry, our captionist, Carol, and of course, Jesse and the Clearinghouse team who make it possible for us to have these webinars. If you have any questions, please email me. Thank you.
Thank you, Carrie.